And we're good to go. All right. Welcome, everyone. I am with David Holt. We are going to talk about independent contractor agreements for therapists. We scheduled this event, I think, early January, and since then, there have been some law changes to independent contractor agreements, and we're going to go over some of that information as well as review what those relationships look like between contractors versus employees as well. We will be, everybody's microphones are muted, but you can ask any questions you might have in the chat. We will get to them as quickly as we can, but we will make sure to try and get to all of them as we go through. All right. My name is Ashlee Secord. I own Thrive Billing Services, as well as a private practice in Minnesota. I'm an LMFT in the state of Minnesota and in the state of South Carolina. David, do you mind introducing yourself?
Yeah, hey everybody, David or DJ Holt, healthcare attorney. I run Holt Law. I also have another business called DocuHealth, which is designed to be templates and training and not legal advice. And happy to chat on independent contractor and health law in general.
That is great because therapists have lots of questions about it. Awesome. So today we're going to review the standards for qualifying an independent contractor, the relationship differences between contractors and employees, overview the relationships that should be employees versus contractors, and then we'll also have some recommendations and resources for protecting your growing practice. And just so you all know, before we go move forward, I'm going to be sharing some slides, and then David has some slides about the compliance with the new laws as well. So we'll be switching back and forth as we go through. But first, before we do that, I just want to get a little audience baseline and ask everybody a few questions. So if you could respond in the chat, where are you from? Awesome. Great. Somebody in. A lot of people from Minnesota. I see some South Carolina as well. That's great. For those of you who have contractors or employees, how many do you have? Nice. That's great. Excellent. Does everyone have a contract in place that they're using for hiring contractors? Some yeses, some not yet. This is a good place to start. Not applicable. Great. Well, before I go on, I think I'll stop presenting, David, so you can share your screen if you'd like. We can start with the new laws.
All right, cool. Let's see here from current slide. All right, are we there?
We're there. I see.
All right. It's now taken control over both my screens, so I can't see anybody but my presentation. So, I'm dealing, as a personal aside, I'm dealing with flies all over my plants. So if you see me bat them away, that's what's going on. I'm not crazy. It's just I've tried just about everything in the book and they just keep coming back. But let's get down to business. So I'm going to focus everything on the recent Department of Labor law rule at the federal level, but I think some of the information will be broadly applicable, and I'll kind of, distinguish where we're talking about federal versus, some more just broad concepts about independent contractors and employees. So basically what happened is the U.S. Department of Labor, so we're talking about a federal labor law department, set a rule into effect, which went into effect 4 days ago on March 11th for basically a more strict classification requirements for independent contractors. So just to, bring this up to a really high level, independent contractors are very appealing for small business owners because they're easy to implement, right? And you don't really have to worry about taxes and employment law. You just, have a written agreement, you W-9, you give them the money, they go worry about their taxes, and you can basically not abuse them, but there are really no worker protections for independent contractors. And so they're a very attractive option, especially for smaller practices that are looking to scale and grow quickly, and especially in the mental health and related healthcare services setting. So the downside of that is with all those benefits comes increased scrutiny from the government. The government, I wouldn't say they dislike independent contractors, but they do have a vested interest in making sure that you classify your workers correctly so that you're not getting some unfair advantage on the system or your, other business owners that are utilizing employees. The big difference between the two is independent contractors, as the name suggests, should be, and you should really think of them as their own little businesses, even if it's an individual. Whereas employees, we exert more control over them. They're not independent. They are part of our company. And so therefore we're in charge of training. We can control, for example, you have to show up to an appointment, whereas a true independent contractor should probably be able to decline a patient appointment. So just high level kind of what's going on. And the government, as you can imagine, with employees gets more of the cut of the money that's going back and forth between the company and the worker. There's also employment law protections, which, regardless of your political views, the government has a vested interest in workers being protected. So without further ado, I'll go over kind of what is happening with this rule. So the rule created what's called the 6-factor test and economic dependence tests. And it's definitely more strict than previous rules. It is at the federal level, so I'll explain where that comes into play and if it even applies to you. If it doesn't, then you're kind of under the radar until potentially you get bigger or you do some of the other things I'm going to discuss. The frustrating thing as a lawyer is, it's a very big gray area of law. So no one factor is, like a Trump factor, like it automatically makes sure that you win. Rather, the government is given the ability to look at the totality of the circumstances or the economic reality of the situation, which, to a lawyer just is not great in terms of guidance. So what does that really mean? First off, whether or not this applies to you. So this is the U.S. Department of Labor. So federal agency, therefore the first question we should be asking is, does federal law even really apply to me? Who would that be? So if you have an annual gross volume of over 500,000 in revenue, you can assume that it applies. If you're in interstate commerce, so I just say for a medical clinic or telehealth clinic, if you're in multiple states, I think you can assume that you, even in telehealth, that federal law could and would apply. If you're accepting any public funding, then this rule would apply. And there's other limited situations which I generally will not go into. Okay, what are the 6 factors? Let's just get them out of the way. So some of these will sound familiar if you've had to go through kind of a quick little analysis at the state level. States are a little bit different in terms of their, independent contractor versus employee factors. I'll be pretty heavy on Minnesota during this presentation, but at the federal level under this new rule, the first factor would be the opportunity for profit or loss, depending on managerial skill, which is kind of a mouthful. I'll go over that one a little bit later. The second one is the nature and degree of control. A little bit easier factor to wrap your head around. To what degree are you controlling the behavior, the schedule, the materials, the everything that the worker does, versus to what extent do you let them work elsewhere and bring their own computer and have their own website and have all sorts of other things. And I'll give some practical examples here soon. Investments by the worker. Number 3, investments by the worker and the potential employer. So am I making investments in my own marketing, advertising, my own business, or am I just kind of, relying on everything that the company provides to me is a factor. Number 4 is the degree of permanence of the work relationship. Does it go on indefinitely or, for a long period of time, versus is it just like a gig or, like a do this project and then we're done. Number 5 is the extent to which the work performed is an integral part of the potential employer's business. It's interesting, the government in their, really long explanation of the rules, which is, very painful to read even for attorneys, but they gave an example where they gave a farm and they distinguished between the farm workers and the accountant for the firm. So even though the accountant, did some very important business for the farm, they were clearly not integral part of their business. Whereas they went into more detail about the farm workers, the apple pickers, I believe it was. And even though they were seasonal workers, they kind of distinguished as to how integral they were. Attorneys, I think, would be another one, although we would probably argue that we're an integral part of all of your businesses. We would certainly not be the core function of a mental health clinic. Number 6 is skill and initiative. So more so on the skill side, highly skilled individuals are going to be weighed a little bit differently than an administrative worker. What's frustrating is that the rule suggested that there may be other factors that the Department of Labor is able to take into account. I think totality of the circumstances and economic dependence or economic reality are already, broad and vague and undefined. And I just want to reiterate that there's no predetermined weight or dispositive factor, meaning that even if you did really well on number 2 and just knocked it out of the park, that doesn't mean that you're necessarily protected. I'm going to give some tips. I can't see the chat, so I'm just going to assume, Ashlee, we don't have any questions rolling in just yet.
One person asked, how do we know when it applies to us? But I think you answered that when you switched to your second slide. Kendall, cool. Did your question let me know if your question was answered.
Okay, great. So I'm just going to give you tips. I didn't have my first slide up, but I'll just put in the blanket disclaimer that all of this is educational. I'm not your attorney. And if you rely on this, and even if it's wrong, you have no recourse against me. So with that said, I will tell you some of the top tips that I have been providing to some of my clients. Each situation is a little bit different. This is a highly tailored representation in the sense that there's a lot of things going on. And in the 6 factors, there's actually sub-factors, and we're trying to get into a very nice part of a gray area as opposed to a more, black and white legal analysis. So I'm just going to go over some of the tips. So I think all independent contractors should file a legal entity and actually utilize the legal entity as an independent business. I posted on my Instagram and TikTok, which, by the way, is another personal aside. I heard on the news that TikTok might be getting shut down, which I'm very sad to hear because I was one of the late adopters of TikTok, and I set up an account probably about a month ago, and our team put a lot of time and energy into it. So I'm actually kind of disappointed that they might break that down. But anyway, I posted a video and I said, listen, everyone, go post or go file an entity, and this should be your first line of defense, and the U.S. Department of Labor doesn't have jurisdiction. That's mainly true, but I probably should have expanded on it and said, you actually have to act like a business too. Just filing an entity and being like, okay, goodbye, I'm good, isn't going to be enough. The entity needs to actually behave like an entity, and the U.S. Department of Labor will look at that. And so just clarifying that, whereas having an entity used to be where I would strongly say, oh, we're good. Now I cannot say that, at least at the federal level. Okay, so second little bullet point or checkbox here is we want to allow workers to negotiate their rates of pay for work provided. In the mental health setting, I think the most direct example would be for your self-pay rates. It would be nice for you to be able to have your contractor say, you know what, I want to charge whatever for a 60-minute session. That is my self-pay rate. You know, I've been doing this for 10 years and I have this extra experience and I think that's reasonable. That would be like a good example. And or there is some sort of business to business back and forth. Maybe the negotiation doesn't go anywhere, but we can at least point to some sort of, you know, business to business negotiation for the rates. It's not just a take it or leave it every single time.
Can I interrupt you, David?
Yeah.
Lindsay asked, what do you mean by we're good and you're protected? Like they're good to continue to work as independent contractors?
You're good and you're protected. Was that in regard to me talking about the LLC?
Your TikTok video.
Oh, yes. I posted and I said, everyone, you know, file an LLC. You should be filing entities regardless, but this would be like your first line of defense. And some people took that as, oh, cool, I just need to go file the entity.
Right.
Then I put in my comments like, okay, you actually need to behave like an entity, because I had a few people go and do that and they're like, I'm good, right? And I'm like, first off, it's not legal advice. Secondly, no, because you need to actually behave like an entity. So that was the clarification there.
Thank you.
Confirm that workers can reject work and choose their own schedule and document as such. So going back to, you know, contractors versus employees, an employee would be one where if they started rejecting work and not showing up to patient appointments, you know, you probably, you know, kick them to the curb. An independent contractor, though, should have the ability, for which you could probably terminate the contract as well, to reject appointments, choose their own schedule. I only want to work, you know, afternoons because I have, you know, my children in the morning, and that's what it is. So having that flexibility is something we would expect to see with an independent contractor, but not an employee. Confirm that rental is optional for contractors or only as a formality to enable billing. So I've seen some clients where they force their contractors to rent rooms at their facility. Kind of rare, probably doesn't apply to too many of you, but again, we want things to be optional, almost like a la carte. So if you had like a menu of stuff that the company was providing, they could consciously check the box or not check the box when they do their independent contractor agreement and make that choice. And I fully understand, you know, with billing requirements, you know, we want them to have the address affiliated. And so what I'm saying, only as a formality to enable billing, we probably have a line that says, you know, this isn't actually, you know, like your space. We consider this almost like a limited sublease simply for the fact that billing needs to run through the company and we need an address for that. All right. We want the contractors, last point here, we want the contractors to do their own training and largely without guidance. So independent contractors should be doing their own HIPAA training. It's one where I see a lot of companies kind of, you know, cheat a little bit. We would much prefer that an independent contractor has their own HIPAA internal policies and procedures manual and goes and does their own HIPAA training, whatever they feel is sufficient. And if there were specialized trainings required for whatever you're doing, we would want them to independently come to the conclusion that they need to do that and go and pay for it themselves and keep their profile up to date. Same point here as the HIPAA CLE, just please stop training of all independent contractors, period. They should really be doing their own. You want to think of them as they're like a hired gun or like a pirate, you know, so they kind of come, they already have their ship and their cannons and they're ready to go. You don't really provide anything to them before they go on their quests. And so you just want to rethink about the dynamic of how you think about an independent contractor. This next one is probably going to ruffle some feathers. So if you have some questions, throw them in the chat. But I would like to see, if we were in compliance with the U.S. Department of Labor rule, I would like to see contractors starting to do more of acting like a business, like I was hinting at before. So I'd like to see them do their own marketing, advertising, other efforts to keep their business looking and feeling like a business and actually operating like one. And then I just arbitrarily say, you know, I want 5 examples if we're going to be in an audit that we can quickly point to and show our auditor, listen, our contractors do 1, 2, 3, 4, 5, you know, get off our review. You know, we know what we're doing. Examples would be a website, you know, their own website, not just sitting on your website. Business cards that have their business and contact information, not like yours, and then, you know, they have their name on it. Paid promotions, those could be web, written, anything really. Booths at conferences, I don't think anyone's ever going to take me up on that, but that would be a fantastic way to show that you are, you know, independently marketing yourself, spending money, going out and showing the world that other people have witnessed that you are your own person. Business apparel, probably not as applicable. Business branded materials, also probably not as applicable in a remote telehealth only mental health clinic. But if you had, what's an example?
Flyers.
Yeah, flyers, pens, you know, kind of like all that little, I guess that kind of goes with apparel, but, you know, stuff that has your logo and name on it. Updating your LinkedIn and other social media to reflect your business name, not just your company's name. So I think like a really easy way to do this is if on your LinkedIn you say, you know, I am a worker at, you know, Holt Law. If you were a contractor, you wouldn't have Holt Law as your current position. You'd have your own business as your current position. And then behind the scenes, yes, you have a contract with Holt Law as an independent contractor, but we don't want that publicly on LinkedIn because the little investigator is going to come and find that and be like, oh, look, you posted on LinkedIn just like an employee would with your position with them. It doesn't appear that you understand the difference between, you know, an employee and a contractor. Removal of contractors from the company website or extremely clear disclaimer of their relationship. So if you're going to run a group practice and kind of do an independent contractor model only, you got to be more clear on your website that, you know, this person is an independent contractor, not an employee, you know, big letters, and making that very clear to anyone that can land on that, which is anyone. It's investigators, it's lawyers, it's everyone with who can access the internet.
We have 2 questions.
All right.
The first one is, do we need to verify that contractors complete their trainings, for example, HIPAA, for the practices protection?
Yeah, you could, without being overbearing about it. You know, in a well-written independent contractor agreement, I'll have a clause that says, you know, they come to us having complied with every other law that's applicable. One of them would be HIPAA. So they would be in breach of their contract. But I guess if we don't trust them and we're just trying to protect ourselves, for which, you know, the independent contractor agreement would protect us again if they didn't do it. But you could do that and verify. I just wouldn't want an overly aggressive paper trail of you telling them exactly what they need to do.
Excellent. Second question is, for marketing, can the company and contractor both spend money on marketing? Can they both utilize the same branding and use the same logo?
No to the logo. unless we were consciously doing some, and it would have to be well thought out and structured, but some sort of like almost third party branding entity that's really only there for us to like purchase little limited shares of the intellectual property, which would be the logo or, the whatever, to go and use in branding. But let's just think of this the easy way. In terms of using a logo, I'm assuming that person means the company logo, to which I would say, hell no. But to regular marketing, if you were both purchasing marketing, that's fine. I'd prefer if you kind of independently were doing your own and not like a joint venture. If the company is doing their marketing, that's just fine. I would expect the company to be doing their own marketing on their own, and then the other contractor to be doing their own as well.
Great. That is all of the questions so far.
Okay. I think we're on the last bullet point here, which was getting the contractor a business bank account and having the payments go to the entity, not an individual. So in a perfect world, on that W-9 1099 issued at the end of the year, I see an entity there. Now, W-9s are unnecessarily confusing because you can have a single member pass through LLC where you can actually kind of just put your name and your social, but you're still an LLC. But at a minimum, I want to see some sort of entity somewhere on that W-9 and 1099.
I believe that in our last meeting, you mentioned that that's also important on the contracts, that you're contracting with another business, and that at the signature page, that the businesses are both listed. Tribe Therapy is creating a contract with Holt Law versus Ashlee Secord and David Holt.
Yeah, 100%. So this is the, creating the entity and the business to business rather than, individual to, and, 90% of the time, the business is just you, right? You're basically just staffing yourself, but we still want to think of it as a business to business contract and relationship, and not think of it. We want to do that. I got some more practical pointers here. I want to see documented advertising or marketing efforts, really just hammering home what I was saying before and documenting it so that we have the proof all ready to go if we're under audit. You know what I mean? So we got, sitting in our back pocket, if God forbid, knock on wood, we're one of the people that gets audited, you already kind of got your ammo for your defense and your proof ready to go. And so even though it might be a stressful and annoying situation to be in an audit, you already got stuff that you're firing back at the auditor, your attorney, your CPA look at that and they're like, oh man, this is a great case. You're really organized, and I think we got a really good shot here. I also, the second little part of this is, if the contractor is bringing in their own business, let's say they're just a fantastic marketer, they went out, they put up a booth out by Lake Harriet, and they somehow, got a bunch of business. They were handing out cards. And all of a sudden, a bunch of people landed on their website. They don't have the infrastructure to actually serve those people. They kind of are just an extension of your company. I would like to see that the contractor is actually compensated differently to show that their marketing efforts are worth something. Not going to be the easiest to do in reality, but that would be a great example of the company and the contracted entity demonstrating that they truly understand the business-to-business relationship. Next bullet point, we're going to switch to a fixed term of a 1-year maximum, which most contracts, independent contractors are, with a negotiation window where we actually engage in meaningful negotiations. So this goes to the permanence factor. The government does not like to see, indefinite agreements where an independent contractor, like an employee, is just working with them forever until they get terminated. They would prefer to see gig-based or project-based compensation. That's nearly impossible in a mental health practice. But what I do want to see happening is 1 year maximum for the term, less if you can get away with it, and then some sort of meaningful negotiation as we approach the 1 year to kind of show again that business to business negotiation. Next bullet point, no non-competes. You shouldn't have been doing this anyway in independent contractor agreements, but now you're going to especially be punished if you have any non-compete language in your independent contractor agreements at the U.S. Department of Labor law rule. Also, this one's not easy and people aren't going to be happy, but do not restrict the solicitation of clients or patients, or make it very clear that clients that they bring, the contractor, independently are theirs, and how we measure that and what to do upon a breakup. So this is getting into pretty advanced, both practical and legal advice as to, how things diverge. No one really technically owns a patient. The patient can go wherever they want. I'm just talking about where you put in provisions where you say you can't, solicit, talk to anything once you leave. These are mine. We want to remove those types of provisions. And if you wanted to really, be impressive on this factor, you would also say, okay, if I bring them in and they come through this marketing channel, which is mine, that we'll kind of label this as a contractor patient. And when we break up at the very end, I get to contact all the contractor patients with my letter that we've already pre-written and agreed upon, and you get to contact all of the other ones. And so we got everything nice and clean, and we're not going to, bicker and threaten board complaints and whatever else you want to do. Last bullet point on this slide is, again, these are like perfect worlds, legal advice, more difficult to implement, but forcing contractors to seek work elsewhere and consider limited contractor work to a maximum of 20 hours a week in order to prevent the economic reality reliance. So I'll go a little bit slower on breaking this one down. The economic reality means that if I'm a worker, a contractor for you, but we, forget the written contract between us. Am I economically dependent on your money and your money alone to, support me? Most of the times in an independent contractor relationship, the answer is yes, for which, I, even before this rule came out, I would be talking to the client, the company about, well, then why aren't they an employee? You want your cake and you want to eat it too. But if somebody's been working with you, and this will come up on the next slide, but they've been working with you for, 3 years, and they work 30 to 40 hours a week, and they only work for you, the party's over, I would say, under the U.S. Department of Labor rule. And it probably would be over anyway if you were under audit, because, this is a classic common law employee. They are only working for you, and maybe they only want to work for you, and they want to be an independent contractor, and they actually don't want to be an employee. Government doesn't care. The government operates under the assumption that people don't know what they want and they can't appreciate it when in a worker relationship, and therefore their attitudes are completely irrelevant. Even if they testified that they are, they love you and they love the setup and they are disappointed that you're being audited, it would hold zero weight in an audit.
I have a question.
Sure.
How about independent contractors using intake paperwork for clients that are the company's intake forms or the business's intake forms?
Using intake forms that are the company's. Yeah, I mean, it's so difficult to use different paperwork, right? You could do it. And I suggested this at my previous, actually a couple presentations. What you want to think of the company as now going forward, if you just want to, be very safe, is you need to think of them as just a glorified biller, right? And maybe marketer. That's about it, right? And if you do it that way, and if you can kind of switch the setup, then the little contractors could use their own paperwork, and maybe they could even purchase or sub-license the use of that paperwork from the company, which is really just a glorified, marketer, biller, business, not a mental health clinic operating as a group. And then each little contractor could create their own no-show fees or rules and their own whatever, and they could kind of slightly tailor their paperwork, right? But I think in the traditional group practice that's going on now, where 99% of the clinics have it set up, they just provide the paperwork and the contractor uses them, which if we look at a multi-factor test, that is bad. But there are factors that I'm willing to fail because they are so critical to business operations, and that's probably one of them, right? It would be so difficult to do it the other way that we're okay with failing that one.
And is honestly probably why a lot of contractors work with other practices is to not have to create all of that.
That's just fair.
Okay. Sorry, go ahead.
Was there a question? I can't see the.
That's okay. Yep, there's one more.
Okay,
if the business is a nonprofit and not a traditional mental health clinic, do any of these factors change?
No. To my knowledge, no. Granted,
yeah, this isn't
focusing
necessarily specific to mental health work like clinics.
Yeah, and to my knowledge, again, this isn't legal advice, can't hold me accountable, but I'm not aware of nonprofits having any special exemptions under labor law rules, period.
Sure.
They have tax, help, but not in terms of misclassifying an employee versus contractor.
Does that answer your question, Kendall?
I will start on the next slide here. So workers likely to be employees. So I take a conservative approach. I'm confident you could find some of my colleagues that would wade into more of the gray area with you, which I'm also willing to do when I'm engaged and let you know how gray we are, right? And what our risk is. I think like any business decision, there's calculated risks. So, we know that we're in a, defensible-ish area, and we're happy with it because we have such a competitive advantage. It's the way we've always been doing things. No one's going to change, and we're kind of pissed at this rule, and so we're going to take a calculated business risk. I appreciate that, but I'm going to cover my ass and give you a nice disclaimer if you actually were my client and say, listen, I can't give you a guarantee that we're good. You're in a dark gray, and I'll try and get you as light of gray as we get. But if you get under an audit and you lose, I'm not paying out anything under my malpractice. And so I respect your decision, but we have gone over the is it the Rubicon, or what's the name of that river? We've passed the point where I can give you any sort of stronger guarantee. So there are some workers that I believe under the U.S. Department of Labor law rule can no longer be contractors. And those are, under this first bullet point, people who by default require supervision in order to work. Trainees, supervisees, whatever. Because, as hinted in the U.S. Department of Labor law rule, and kind of a long explanation, supervision is such an intimate relationship that there's no way that it could possibly be labeled as an independent, you can operate without it. You can't. Like, that's the whole point. Now, I've already, dreamt up some loopholes to this. I suspect some of these supervisor third-party companies might start popping up. And so rather than your company, the company that's, the group practice being the supervisor, you actually kind of force them to go and use other supervisors. And so all of the liability is kind of outside of your entity, and it's their job to go figure out who's a contractor or employee. But they show up as a, already supervised supervisee, ready to work and bill and all that. Also, as I hinted in at the previous slide, there's just no way if you have somebody who's been working for your business and they're basically a lifer, they've been doing it for multiple years, 30 plus hours a week. They're only working for your company. They have no desire to work elsewhere. They could probably never see themselves actually launching a website and putting their, their photo on it. This is my signal to you that you need to switch them to an employee. And I just don't have a good way to defend you on that one, nor would any competent attorney. So probably not what you want to hear, but that's basically a common law full-time employee, regardless of what you put in a contract.
We have two
All right.
questions when you have. Is this a good break?
Yep.
Great. Can independent contractors be included with, I think they mean a company address or email address within the group for ease of communication and for ease and directness of communication?
They can, but it's a factor that the government will grade against you.
Okay.
The alternative being that little contractor, well, not little, that worker contractor gets their own business account. We have a business associate agreement with the company, and then we coordinate communications accordingly.
Essentially from your business email to their business email.
Yeah. So the contractor would have their own little, domain attached to their email, and therefore not be using the company's email servers or emails.
Perfect. Next question. What if I am an independent contractor for a business and I have all the other things in place, LLC, my own practice, my own website, my own clients, but I take medical assistance with the company I contract for? Would I have to eliminate my MA clients to continue being an independent contractor? Also, I'm under supervision, but my supervisor is not affiliated with the business. I hire her through my business.
Well, it sounds like you're good on the supervisor part from my understanding of the facts there. The previous one, I don't think it's a do or die. I think it's one factor among many that you partially fail. I mean, the fact that you're taking medical assistance through the group, and this is kind of the allure of joining a group, is that they have all of the insurances, and I get it. I get the business proposition, but I think it's one that you just have to fail, because otherwise, if we were saying, we don't want to use the group as a biller, then why do we even have group practices with independent contractors, period? So I think it's just one that you fail. I don't think you need to dump your MA clients. I mean, you could, but at that point, why don't we just kind of go all the way solo? What more is the company providing at that point? Maybe they're billing, I don't know, or marketing.
Okay, because her solo practice is private pay. And I'm assuming if she's under supervision, she can't get her own MA contract to see those clients.
Oh, I see. Okay, she's under supervision. Yeah. Also, not to panic that individual, but some boards in Minnesota take the position that a pre-licensed individual, however they label themselves, cannot have their own entity and just utilize supervisors. Basically, you have to shack up with a licensed company, and that is completely dependent on the board. That is Minnesota specific. I can't comment on anywhere else. And so just a word of caution. Fortunately, it's pretty loosely regulated, and most people are grossly incompliant, and it's not a enforcement priority for the boards. Okay, I got some resources here. I'm sure that Ashlee can email out these slides to you all, and happy to take other questions, but I'm actually going to close my thing so I can actually see people again.
Sure.
So I'm going to stop sharing and exit that, and I'm back. All right.
Excellent. Well, we covered all of the questions. that came up. Does anybody have any other questions before we sort of go through the relationship differences between employee versus contractor, which I feel like we've already gone in great detail. This is just a contrast. Amanda asked, should the independent contractors submit their own claims? Oh, can't hear you all of a sudden, David.
Yeah.
There you
Yeah,
go.
that'd be great if they could. It's showing they're doing their own stuff. I guess again, all these questions kind of lead me to ask a question back, which is, if you start doing more and more and more of these things, you've almost become your own actual business. It's kind of like,
right,
it's what the government kind of wanted in the whole scheme of things, and now you're your own entity, and you just got to weigh the utility of the company, for which I think there are others than just billing, of course. But yes, it would be a good factor to submit your own, although probably pretty annoying to do.
Any other questions? Awesome. Then we'll go into the contractor and employee dynamics. And I just created some easy contrasts for the differences between those relationships. So some of this might be repeated from what David said. And David, if you have anything to add, feel free to chime in. For workload and availability, a contractor is going to have other clients and jobs away from a contracted position, and their availability to a company might be more limited. For an employee, they're typically dedicated specifically to one company, and they have set schedules with availability expectations from the company. Add anything else to that?
No, it's a good summary.
For marketing and branding, we went into detail about this, but I'll just reiterate. The contract has their own filed business. They have their own website, business cards, brand identity, and are advertising their practice independently with their own money. An employee represents a brand and image of the company. They require to adhere to specific branding guidelines, and they are not paying for the marketing. Decision-making and autonomy. A contractor can choose or reject their clients. They also choose their schedule and the hours that they're working, and they also choose where they work. So this would be like if they have their own office space, if they want to rent office space somewhere else, or working from home, that there's an option there. Employees follow established protocols, procedures, and guidelines. They have less autonomy in schedule and responsibilities, and may be required to work in the employer setting. Training and development. The contractor is responsible for their own training and costs related. The expectation is that they are staying current within the changes of the field and the expectations of the field. For employees, the company may invest in training and development programs, and there may be opportunities for career advancement and skill building. Equipment and resources. The contractor is using their own equipment, tools, and resources to complete their work. They're going to be responsible for maintaining and financing their equipment or workspace. Employees are going to use equipment and resources provided by the company and have access to company-owned tools, facilities, technologies to perform their duties. There is a question for independent contractors having logins to EHRs in order to sign off on supervisee notes.
What about the independent contractor having login to the EHR in order to sign off on supervisee notes?
So I think they're talking about the fee related to the EHR.
That the contractor is paying it, or?
I'm going to assume, what about the independent contractor having login to the EHR? So there's a cost related to that login. And I know some contract agreements include a fee for that access, and some include it into the percentage. And I'm going to guess that David would recommend that they are being charged for that fee, and it's being added to the a la carte option.
Yeah. I mean, EHR is, again, it's one where I don't think it's possible to have each little contractor get their own EHR and then try and figure out some goofy way to get all that to insurance. So I think the assumption is that they have to use your EHR. And then from there, I think the question, as I'm breaking it down, is that okay, in order to sign off on the supervisee notes? The answer is yes. But the use of the word supervisee makes me wonder if you're actually asking about a supervisor that is not the contractor, for which I would also be okay with that, because how else would you, actually access the record? So again, there are some factors that we fail, or little sub factors of the main factors, that in a mental health practice, we're not a apple farm like one of the examples in the public record there. We just have to fail by the nature of how this is set up if we're going to continue to use contractors and kind of try to get ourselves in a defensible area.
Excellent. Yeah, go ahead.
Yeah, so if the company has equipment, modalities to use within sessions, are the independent contractors able to use those? I mean, again, yes, but it's a bad factor. So I would prefer that the contractor brings their own modalities to use within sessions. That would be a great thing. That is the contractor spending money on their own stuff, for which presumably the rate is, enough to cover all the stuff that they're now buying on their own, and they bring that on their own and not, again, use the company's materials, is what I would consider that. The company pays a fee to allow the login, otherwise the supervisor can't do it at all. Okay, that was the clarification of the question. That's, yeah, I don't know how else you would do it. So okay, but not great, but really just a sub factor that is not great. Let's say we all think we're above board and continue with the independent contractor dynamic. What happens if the Fed disagrees? What's the recourse? Fines. So money. So technically there are criminal provisions, but that's usually when we are blatantly and purposely and unapologetically breaking labor law rules, in which is very different from, I hired an attorney, we moved to a defensible position, we did change a bunch of stuff that I can show you in the audit, and all right, we disagree with your analysis, but that was really close. In that situation, effectively what the fine is going to be is, had that person been labeled as an employee, what would it have been paid in taxes to the government? And if you were really working them hard and not paying minimum wage or overtime, you might need to pay that as well. My argument is, if we get to that stage, and technically they can fine you on top of that, but for first-time offenders, I have not seen in my career them actually keeping fines on top of that. But let's say we get to that stage, right? You've probably gotten such an economic advantage up until, going through that audit, that I don't think you're going to be too disappointed with that. Maybe you didn't budget for it, but my argument back to you is, probably a lot of your colleagues are switching over to employees right now, or have, hired counsel and made all sorts of changes. It would be unfair if the government, kind of gave you a nice pass and, didn't equally enforce to the others that did comply. So just playing the devil's advocate there quickly. Okay, but also to expand on that, I know the rule went into effect 4 days ago. You probably haven't had the, independent contractor police knock down your door and arrest you. So I think that enforcement wise, we're in an election year. Prosecuting small businesses is a very poor political decision, regardless of your affiliation. And so I think that from a practical perspective, also there are pending legal challenges. And so I've had some clients that are basically betting the farm on a legal challenge, overturning this, or probably a Republican president being elected and overturning it. I think that enforcement is going to start with I'm going to call them the unapologetic offenders of labor law, which would be generally gig-based, like Uber, DoorDash. You basically have people that only use an app and go and do all these things and have been classified as 1099s. And those companies are skirting around a ton of taxes. So I think those are going to be the focus of enforcement. Then you kind of work your way down to, let's just say, large mental health practices that are doing this unapologetically. And then we get to, we'll just say under 25 staff type practices. And again, enforcement power, I think it would be random. So you'd be quite unlucky, or it would be one of your contractors that's pissed at you about something else, but they heard about this thing and now they have leverage and they go submit a complaint and now, oh crap, we're under investigation. So I know we're at 1, but why don't I sneak this one in?
It's one more question.
LPC site supervisor be categorized as an independent contractor? If this there. It's like a tongue twister, only function and they follow all the other factors. All the other kind of site supervisor. I got to stick to my original guns on supervision is so intimate. I just don't see how that could be provided as an independent contractor, unless you're talking about my third party supervisor setup, then that's okay. And I'm assuming we, by you, I mean the small contractor, doesn't care at that point, because if the government came in and was pissed about that independent contractor, it would be between the two of them, not you, not the lowly other third party. So that's the distinction there.
Great. I think we covered everything. I just wanted to post the resources for David's companies. Do you want to talk about DocuHealth at all?
Oh, yeah. Admittedly, I haven't been able to give it as much time as I'd like. Sorry, these darn. If anyone knows how to get rid of those gnats, I've tried everything in the book. Put it in the chat, because I figured out how I got them in. It's because my soil that I purchase, apparently you're supposed to bake your soil or sanitize it, and so they're actually coming in through the new soil that I bought. So I think I've identified why it keeps reinfesting, and then I eliminate them. Anyway, DocuHealth is designed to be not legal advice, so do it yourself, way cheaper. But a very common theme that I see is, oh, well, can you kind of come back and just tell me all the stuff that I didn't get in the legal advice? And it's like, well, no, that's the whole point. You're kind of more of a DIYer, assume the risk a little bit on yourself. So generally those are not state specific, but get, a good portion of good legal provisions that you would need. We also do video trainings on there. Not a whole lot right now. Well, actually, I would say none of my video trainings are specific to this audience, but that'll be greatly expanding over the next year to be everything from, HIPAA training to more specific partnerships with actual mental health professionals. So it's kind of like a quasi-legal, almost like a CLE. Anyway, that's DocuHealth. And then the other one's my firm. And we do practice in this area. Happy to help.
Awesome. You've got some soil recommendations.
Oh, good. I'll read those. I'll read those silently as you.
Here's some offerings from Thrive Services. We offer contracting and credentialing. We also have monthly billing packages, and we also do private practice consultation. And we have a QR code if you're interested in a free quote. Otherwise, we have a free quote questionnaire on our website at thrivebillingservices.com. Thank you, everyone, for joining us. Thank you, David, for giving us so much information. And I will gladly send out both slides for everyone to review. Yeah, I'm glad it was helpful for everyone. Thanks for coming.
Yep. Thank you. Have
Thanks,
a good weekend.
David.
Yeah, you got it. Okay. Bye.
Yep, bye. Absolutely. I'll send one out, Lindsay. Bye.